the hearsay evidence which is otherwise not admissible becomes admissible under section 6. पता है आपको मैं examples देके both in civil cases and criminal cases. Then the scope of section 7 is much more wider. I took up the plea that here we informed you that here facts which are the occasion, cause and effect, immediate otherwise, are which are relevant, which are involved both in fact in issue and as the relevant fact. Is very important. The cause and effect, and I gave you I cited today, shared with you the judgments, some of the judgments of the Supreme Court on section 7 and 8 दोनों में है वो. When you see the section yeah, एक minute, I'll just close the phone, people will trouble me. एक मिनट कर देता हूँ, अभी इसको एरोप्लेन मोड में कर देता हूँ, and also reduce the volume ताकि you will not disturb. Yes. Yeah. Now, for the purpose of this section 7 and 8, which is very, very wide, very, very wide, I have given you I will just only give you the brief gist of each of the cases without wasting much of your time, because we have to cover other sections. Now, the first judgment which I have given you, the judgment of RM Mulkani versus State of Maharashtra, उसके अंदर चेक करेंगे आप. This is also reported in. If you want to take it out for your benefit of the others, everybody, please just check it out. This is reported in. This is reported in AIR 1973. Yeah, 1973 Supreme Court, page number 157. Now, यहाँ पे the brief facts relating to this matter is here is what is the effect of illegally tape recorded evidence, wide tape recorder. Each facts I'm not going much in detail. In a nutshell, in RM Mulkani case, Mr. Mulkani is a coroner of Bombay. The gentleman responsible for giving certificates. He is a quasi-judicial authority who is supposed to be investigating the cause of death when the operations are performed by doctors, when death take place accidentally or otherwise. He will examine whether there was a negligence of the doctors or not. In one such case, normally when such patient dies in suspicious circumstances, the police authorities, they recommend inquest report. That is under section 174 of the CRPC. You learned what is inquest. Why inquest panchanama hoega? The police will investigate, even the magistrate conducts investigation. For this purpose, we have a Coroner's Act in India. Under the Coroner's Act, Mr. Mulkani was the coroner in the city of Bombay. Yes. Then when an operation was performed by one Dr. Aditya in a Bombay hospital, the patient dies, unfortunately. The hospital authorities, at the direction of the police, referred the case. They said that we would like to have autopsy report. But unfortunately, what happened, Mr. Mulkani was on leave, and then he appears to have demanded certain money, 20,000 rupees, for giving a favorable certificate to doctor to give him a clean sheet. And he ordered that the body be disposed of, which is against the directions of the police authorities. And the doctor was not agreeable to pay 20,000 rupees. Then he reduced the amount to 15,000. 10,000. 10,000 reduced करने के बाद the messenger who was an in-between gentleman, go by Dr. Motwani. This matter is also on the YouTube. You can see that Mr. Motwani reported that he is not agreeable to pay that much money and he cannot pay. Then reduce करने के बाद एक meeting, ultimately a meeting was arranged. They filed a complaint with the Anti-Corruption Bureau. वो ट्रैप किए उनको, एविडेंस कलेक्ट कर लिए, एंड अटेम्प्ट, देन अल्टीमेटली he demanded, raise the amount to 15,000 rupees, stating that surgeon has to be paid money. Now the issue before the Bombay court was Sessions Court and the High Court. The High Court took up the view that Bombay High Court, yes, illegally collected evidence may be received in evidence, but यहाँ पे the evidence has been is in contravention of the provisions of the other laws. When it is in other laws में contravention है, evidence की evidentiary value क्या होगी? That was the issue before the High Court. Then when the High Court dismissed the writ petition, dismissed the appeal of the accused person, the matter went to the Supreme Court. In the Supreme Court, the issues before the court was, number one, whether the prosecution authorities are entitled to receive illegally collected evidence, number one. Whether the tape record evidence which has been collected is in breach of the provisions of Article 20, subclause 3 of the Constitution of India. Whether the evidence so collected amounts to statements under Section 162 of the CRPC, then what is the validity effect of this? उसमें सब चीजें लिखे गए, beautifully enshrined. It's a judgment given by Justice Ray for the bench, who was not impressed by any of the submissions, because probably according to me, so he said that under Section 25 of the Wireless Act, the even if a breach is committed, no problem. He said that here in the present matter, there was no damaging of any of the wirelesses, and violation has been not taken place. Evidence can be taken on record relying upon the earlier judgment of the English court in Maqsood Ali's case, R versus Maqsood Ali's case. Now, usse pehle, before Mulkani's case, we had a case of a gentleman called Yusuf Ali Nagari's case, 92 Supreme Court, 62 Supreme Court, I have circulated. In that case, the landlord of a building in Mumbai, whose wife was the landlady, did not keep the premises in a tenantable condition. It was allowed to be deteriorated. So the municipal commissioner issued a notice under Section 354, inter alia, holding that the building is in a ruinous condition and get it demolished. This gentleman, Yusuf Ali, what he does, he with a view to get the notice annulled, and he takes out money and wants to bribe the municipal engineer, Mr. Sheikh, and he reports the matter to the Anti-Corruption Bureau, and who recorded the evidence against him in the matter. That was used in the court of law and proved against him. There the issue was, can the illegally collected evidence be used in the matter? The Supreme Court held that in the affirmative, yes, the source of it is not material how the evidence has come. If it is relevant, it is welcome. That was the issue before the English court in R versus Regina versus Maqsood Ali's case, which I have sent you earlier. That they are not bothered how the evidence is collected. Relevant है, use कीजिए आप. But the concept is different in the American courts, where they do not use the illegally collected evidence, which they characterize it as fruits of the poisonous trees, and it is better to avoid those fruits. So they don't take it. Now the Supreme Court says in these two judgments, the evidence recorded in a tape recorder is a contemporaneous evidence, and it may need corroboration, need not need corroboration. Because if it is directly device is used, it becomes a primary evidence, and the people who are responsible, there is no coercion, and the presence of the police officer doesn't become make this statement under 162, because the police officer is not directing, is only keeping an observation as helping as to how the instrument works, and only remaining present. That's in the matter. You know that a statement recorded by a police officer under 161, 162 or 8, they cannot be used as evidence. They need corroboration. So the gentleman R.M. Mulkani took up the view that here, the tape record evidence which has been recorded is, apart from being illegal, number one, It's against Article 20 subclause 3 of the Constitution. That is, it had the effect of incriminating me, and I cannot be. So incrimination part I read it to you earlier, comes into play when the party is during investigation. Now, यहाँ पे this is a stage of using the evidence in the court of law under the provisions of Section 133 of the Evidence Act, where the witnesses cannot say no. So the court will see whether the evidence is reliable or irreliable, whether admissible or not admissible. So they are connecting this evidence, Supreme Court, under Section 7, which says that here it has the cause, it is the occasion. The occasion was that the demand of money. Huh? The cause was that here, on account of such a demand, the occasion, the reporting has taken place, and playing of the conversation is the effect of the fact in issue, namely demand here. So they will straightaway fit in Section 7 of the Indian Evidence Act, is therefore admissible in the matter. Now let us see what is the effect. These all judgments which I referred to you of the year 1962, 73, and also Maqsood Ali's case, ये सब बहुत पुराने judgment, when before the secrecy judgment came privacy, that is Puttaswamy's judgment. Now Puttaswamy's 9-bench judgment takes up the view that here right to privacy is a fundamental right. Now when a fundamental right is, in breach of fundamental right you are collecting some evidence can be used against you, and according to me the 9-bench has to examine this issue. Some of you go through this and let me know. I have not very cursorily gone through the Puttaswamy judgment, but just roughly gone through. But when occasion arises, I like to go through incompletely. That may be useful to me also in many matters and also for discussion with you all. We have to check it up whether the 9-bench judgment of the Supreme Court in Puttaswamy, what does it say about the illegally collected evidence? Yes, there is a fundamental right to privacy, no doubt. But the privacy is not an absolute right under the Indian Constitution. It is always subject to reasonable restrictions as contemplated under Article 19(1)(4) of the Constitution, isn't it? The explanation है उसके अंदर, तो वो देखना पड़ेगा. I recently came across one Delhi High Court judgment of a single judge. When an evidence is illegally collected, you cannot use it. But the division bench of the same Delhi High Court takes a different view. So there is no unanimity judicial decision के अंदर as to what should be the correct view. But again, a very vast discretion is given to the trial court. Please note that because the trial court is watching the demeanor of the witnesses, how the witness is deposing, whether truthfully or giving a false evidence. So he can bend it the way he wanted. In some of the judgment, it is said that even if the illegally evidence is very harsh, it can be used. But if it is very prejudicial, it cannot be used. Now, in NDPS matters, one judgment I circulated to you yesterday, very important judgment, that is the judgment of 5-bench judgment of the Supreme Court, which you may be aware of it under the NDPS Act. If there is a non-compliance by the police officers, the officers of Section 50 of the NDPS Act, namely, investigation can only be conducted in the presence of the magistrate or a gazetted officer. All of you know that. Those of you doing the NDPS matters will know that. If there is a violation takes place, if the NDPS, if the investigation doesn't take place in the presence of the magistrate or in the case or before the gazetted officer, some of the Supreme Court judgment earlier held it is a irregularity. It can be condoned, but the Supreme Court 5-bench judgment in the state of Punjab versus Baldev Singh, 21st July 1999. That is a constitution bench judgment given by Justice A.S. Anand, Justice Mujumdar, Justice Shujata Manohar, Justice Venkataswamy and Khare. This judgment check कर लीजिए आप. यहाँ पे clearly कहता है कि under the NDPS Act, because Narcotic Act is a very serious act, if the investigation officer breaches the provisions of Section 50 of the NDPS Act, which mandates that investigation can take place in the presence of the magistrate and in the presence of a gazetted officer, and evidence used in contravention cannot be used against the accused, and he will be entitled to acquittal. He cannot be convicted. That you please go through this. Now, according to me, in the light of this judgment, but the Supreme Court made it clear that the judgment is applicable to the facts of the case and under the NDPS Act. Then what happens to under the general law of the land, under the offences under the Indian Penal Code, and collection of the evidence for other civil cases purposes? That's a very vexed question of law which need determination by the Supreme Court larger bench in the matter, because there are so many conflicting judgments we have and we need to address to it. So please, you go through this judgment of, apart from RM Mulkani, which permits illegally collected evidence, and Baldev Singh judgment doesn't permit. State of Punjab versus Baldev Singh, 21st July 1999, वो देख लीजिए आप. तो उसके बाद मेरे ख्याल से 5-1 जजमेंट के बाद देयर इज नो अदर जजमेंट, बट देन पुत्तस्वामी जजमेंट इज वेरी इंपॉर्टेंट. द राइट टू प्रिविलेज, उस जजमेंट में देखना पड़ेगा क्या करेंगे. ओके, इफ यू डू दिस यू विल कम टू नो हाउ टू यूज द एविडेंस, illegally collected evidence. Okay, now I will now proceed to discuss with you section 8, motive, preparation and conduct. Anybody has any question to be asked me in section 11, please do feel free to repeat it. So यहाँ पे देख लिया हमने. फर्स्ट एग्जाम्पल दिया रॉबरी के बारे में, cause and occasion. Second example में marks of marks on the ground produced by the struggle is also relevant, cause and effect. Then state of bee's health before symptoms, describe poison. जो poison दे उसने, उसका report of the expert can be shown to show that that has taken place. Now the next section also deals a very important motive, preparation and previous subsequent conduct. The motive, इसमें mens rea वाला में, ये mens rea दे check करने के लिए काम आएगा. Intention, the reason क्या है murder करने का, robbery करने का. Now let us see this section. Any fact is relevant which shows or constitute a motive or a preparation for any fact in issue or relevant fact. So our motive mean A has been dispossessed by virtue of a decree of the civil court and B attempted to murder him. That is the motive behind. One example. Preparation. Young people, youngsters, young generation, they wanted to become overnight rich. They were making preparation to commit dacoity in a bank or luto their friend's family, rich friend. Such preparation. So preparation, that evidence can be led of any fact in issue, relevant fact. Now let us see the illustration, how to illustrate. Then the conduct of any party, or of any agent or an AG agent to any party or to any suit or proceeding in reference to such a suit or proceeding or in reference to any fact in issue therein, relevant thereto, and the conduct of any person, an offense against whom subject to any proceeding is relevant if such conduct influences or influenced by any fact, issue, relevant fact, any other previous or subsequent fact. Now to understand this section, I will explain to you each and everything. Now section 8, the first limb, embraces both the civil and criminal proceeding. Now the first part will deal with the civil cases where the conduct of a party or of any agent. Now in a civil cases, under the Indian Contract Act, section 201, 202, 203, 16, 17, agency of the camp, law of agency. You appoint an agent to do a business on certain commission. An agent is responsible for the act. Now there's a misappropriation take place. An agent doesn't give you an account. There's an offense of misappropriation under section 403, 404 takes place. And breach of trust हो जाता है agency के अंदर. The offenses under the provisions of section 406 and 409 लग जाएंगे इसके अंदर. When such an event, the conduct, what was his intention? You can examine, principal can examine the agent or the persons who had dealt with him to find out his motive. What was his intention in cheating? A misappropriation or bank account मंगाएंगे, detail मंगाएंगे. देखेंगे in any suit or proceeding. in any suit or proceeding, वो देखेंगे आप. Let me just close it here. I need to close this because otherwise people will trouble me. Yes. Now, so section 8 is starting giving with the example of a principal and agency cases, or next is or reference to the fact in issue relating to a conduct of any person, an offense against whom is subject to any proceeding. Now, the conduct of a person, for example, here in criminal proceeding, the previous conduct, previous conviction is relevant. Now, you have a right to ask the accused person. Now, when you normally in civil cases, the previous conduct is irrelevant. Please note that. How you can ask the question, please just turn to section 52 खोल लीजिए आप. In civil cases, character to prove conduct imputed irrelevant. Section 53 में check कीजिए. In criminal cases, previous good character relevant. Now 54 कहता है कि previous bad character not relevant except in reply. If the accused takes up the plea that I am a man of virtue, I am a good man, I have been a saint, I am a philanthropist, मैंने गरीबों को इतना बांटा है, then you can contradict him. You can examine so many people to prove that what was his conduct. So he can also take up the plea here under section 8 to show that his conduct is very good, conduct is very bad. That you can show that here. Illustration से बताऊंगा मैं आपको, clear हो जाएगा ये. Or when you offend the subject of proceeding relevant, if such a conduct is influenced by any fact in issue relevant. So to show that the agency business may the misappropriation took place on account of the ill motives of the agent, you can prove it. Misappropriation took place because he did not want to give the profits to you, and you can also show the conduct of a previous good or bad character in this regard to gentleman. Now explanation 1 check karo aap. The word conduct in this section does not include statement unless those statements accompany and explain acts other than statement, but this explanation is not affect the relevancy of statement under any other sections of this section. So this section not include this statement. See, mere statements are not admissible. Like section 161 also bars statement given to a police officer is not admissible unless they are corroborated. Accompany, explain the acts. They need to be corroborated. They need to be supplanted. You have to examine another person to show that this happened. A police officer recovering articles pursuant to recovery under section 27 from the accused person. That recovery itself doesn't become evidence unless it is corroborated. Unless you examine the punch witnesses under section 10103 of the CRPC who were present. So the statement must be explained. The reason why we have been called by the police officer. The reason क्यों बुलाए हम, आने की वजह क्या है, हमारे सामने रिकवरी हुई, accused की पूछताछ हुई. The accused made a statement. He has कोई नदी में या कोई bushes में उसने weapon छुपाया था, बॉक्स छुपाया था containing incriminating articles. हमारे सामने रिकवरी हुई है. So that will show, that will prove these statements. So the statements normally which otherwise are not admissible under section 25 and 27, they become admissible under 27 if it is corroborated under section 157 using the statement of the witnesses who have been summoned and brought by a police officer under 100 CRPC and 103. So इसका मतलब यहाँ पे आप connecting. Explanation 2 check कर दीजिए. When the conduct of any person is relevant, any statement made to him or in his presence and hearing which affect his conduct is relevant. Okay, conduct of a person relevant, any statement made to him. So while the police officer holding a parade, maybe holding a parade, for identification of the witness. See, in that identification parade, which is conducted before the executive magistrate, certain statements are made by the accused person. Those statements which generally are not accepted as evidence, they are made in the presence of the executive magistrate and the identifying witness, they become admissible under section 8 explanation 2 read with section 9, that is fact necessary to explain, introduce the relevant fact and to find out the identity of the person. आप section 9 check करेंगे तो आप मिलेगा. Now here section 8 you will understand better, which is a very little slightly difficult section or very interesting section to show the mens rea, the conduct, ill feeling उसके दिमाग में, they normally to prove circumstantial evidence. Because the witnesses may lie, documents may lie, the circumstances, what is there in your mind, especially a person has committed adultery, an offense which was formerly not now, or fabricated a document, थोड़ी बोल के करेगा आपका signature हो. These are to prove the hidden crimes. Circumstantial evidence is very important to prove. Section 8 comes into play. Let us see the illustration. Illustration से आपको समझ में आ जाएगा. A is tried for the, just I will a sip of water. Just give me. या इलस्ट्रेशन ए, ये इलस्ट्रेशन काफी इलस्ट्रेशन है. आज ये सेक्शन खत्म कर लेंगे. आज के लिए सेक्शन 8 काफी हो जाएगा आपके लिए. नंबर 1, A is tried for the murder of B. The fact that A murdered C, that B knew that A had murdered C, and that B tried to extort money from A, threatening to make his knowledge public or relevant, is very important. देखिए, A murdered C, यहाँ पे A ने मर्डर किया C को, और B is trying to blackmail him. B को मालूम हो गया कि A ने मर्डर किया है. अरे भैया, तुमने तुम्हारे फ्रेंड को मार दिया है मुझे, I know very well. I was watching it very well. You want me to suppress this fact and not to tell anybody, though I am an eyewitness? You have to pay me 1 crore. He's a rich man. Otherwise, I will see to it that I'll report to the police and you go to gallows. So यहाँ पे he tried to extort money from threatening to make his knowledge public or relevant. So during the trial, evidence can be led to show that in a trial, to show that threats were given to him. I mean, in fact, a murder has taken place. And C is a eyewitness. And he has recorded statement to the police. And maybe a tape record evidence, or maybe some other evidence, or maybe a direct evidence, or evidence that he gave threats. वो बोलेगा मेरे को threats मिल रहे हैं करके. Threats मिलने की वजह है कि so यहाँ पे दोनों crime के facts are correlated now. So merely you cannot take up the plea. Murder is different from blackmail or extortion. You cannot lead evidence. You can lead evidence here. It is connected because it is connected to the fact in issue. It is the cause and effect of a occasion with regard to fact in issue as well as relevant fact. Okay, B देख करें आप. A sues B upon a bond for payment of money. B denies the making of the bond. The fact that at the time when bond was alleged to be made, B required money for a particular purpose is relevant. So A and B are very good friends, childhood friends. A के घर में शादी थी, शादी ब्याह के लिए B could बोला भाई I need money 1 lakh rupees which I will give you after a month's time or maybe 2 months time. उसने बोला सिर्फ प्लीज एग्जीक्यूट ए बॉन्ड. तो मे यू मे बी माई गुड फ्रेंड बट मनी मैटर में वन मस्ट बी केयरफुल. बॉन्ड दीजिए आप, आई विल गिव यू मनी. सो डिड नॉट इंसिस्ट फॉर मच रजिस्ट्रेशन नहीं करे, खाली बॉन्ड ले लीजिए, अ सिंपल बॉन्ड. इट मे बी रजिस्टर्ड अनरजिस्टर्ड बिटवीन टू फ्रेंड्स, दे मे नॉट बी रजिस्ट्रेशन फेथ के ऊपर कर दिया. बट व्हेन इट कम्स टू मेकिंग मनी, बे बोला कौन सा पैसा, कहाँ का पैसा, आई डोंट इवन नो, आई नॉट टेकन इट. So B will file a suit for recovery of the money on the basis of the bond. He will take up the plea. The other side, the bond is not a valid document. It is not registered. But sometime under the Evidence Act, under the Contract Act, even oral evidence, you can lead to prove a contract. You know that, no? Under Section 9 of the Indian Contract Act. So you will say that there was in the cross-examination में सवाल पूछेंगे, was there a wedding in your family and so your son got married? Yes. You also invited me? Yes. आप ये पूछेंगे wedding का सवाल, how relevant to the bond? And I will tell you. And you also invited me. And just before the wedding, and I put it to you, you told me that you wanted to buy some jewelry. You wanted to give it to your daughter and son-in-law. You asked me to give money a loan, which was given to you. I put it to you. So you put up your suggestion to him. And put it to him, this is your signature or not. So the fact that there was a marriage in the family, and on account of that marriage and occasion, he had come to you requesting for a loan, that will show the conduct of the defendant in making. What was the reason for the? That was the reason. That was the motive. That was the mens rea, and that was the previous conduct. The loan was taken by you, and which you are denying it. So the fact relating to the marriage you attended, the loan was taken. You may ask him in cross-examination, where did you get the money from? From where did you arrange? You never had. You are a man with meager means. I had given you the money. So you may examine one or two witnesses who are witnesses. So put up your case. I put it to you that there was in your marriage, in your family, you were in need of money. You approached me. I gave you the money, which you are unfortunately, dishonestly disputing the bond. So here you are leading a previous evidence with regard to leading his previous conduct and the motive for giving the loan. Okay, समझ में आया ये बात? नहीं आया तो please do feel at liberty to ask me. Number 3, A is tried for murder of B by poison. जहर दे के मार दिया. The fact that before the death of B, A procured poison similar to that which was administered to B is relevant. So the police officer will make inquiries from the nearby shop, because a poison was found in the house of the B's wife. Bolegi, this was the poison his friend had come and given him. They had an enmity, or there was a civil dispute under which a decree was passed in my husband's favor. He invited him for dinner and he gave poison, and he died immediately. So the police confiscated the poison. So the police officer makes inquiry in the locality, a poison कहाँ से लाया गया था? So nearby shops, they were chemical shop, they must be medical shop, kirana shop. Inquiries पर kirana shop बोलेगा yes, ये particular poison का डब्बी ये हमारे पास से ली गई थी. This was purchased yesterday by a gentleman whom I know very well. He stays close by. So that evidence is he made preparation to commit the act of administrating poison. So this evidence you will be leading to show that A made preparation for causing the murder and also his intention, which your wife will narrate that there was a decree passed against him in a civil court. He wanted to settle and retaliate. Number one, even if there was no motive, you can say that he made preparation. That preparation is coming under section previous conduct. See, motive preparation. He went to the kirana shop nearby. He purchased it, administered evidence of the. You will be the prosecution will examine him as a witness of the prosecution. So his evidence cannot be shut. You cannot take up the plea. How kirana shop owner is relevant for the purpose of the poison? No, he is the person who purchased it from. It is very important witness to show that he had pre-planned to administer poison and kill him. Okay, ये evidence यहाँ पे connect हो गया. Yeah, next आ जाइए अभी. Then the fact that before the death of B, हो गया. Next D. The question is whether a certain document is the will of A. So यहाँ पे dispute है whether with regard to the will, which is normally happens in most of the families. Now the fact that not long before the date of the alleged will, A made inquiries into the matters to which the provisions of the alleged will relate. He consulted wakils in reference to making the will, and that he caused draft of the wills to be prepared of the will, which he did not approve or relevant. So there is a sibling rivalry going on in the family, where in most of the families, such rivalry over especially a father who left behind, a grandfather left behind a big fortune. Isn't it? Her family mein hota hai, human nature changes. Huh? Circumstances changes, human nature changes. So a son will take up the plea, elder son, father made the will in my favor. B will take up the plea, father died intestate. समझना आप? So the B will, one of the parties will try to lead evidence that my father's family lawyer is Mr. X. Okay, my family father's lawyer is Mr. Kumar, isn't it? Ashutosh Kumar. So he has been consulting him and meeting him. And he made draft and gave him for his approval. And the drafts were not approved by him. You know, the will is not valid under the Indian Succession Act unless it is attested by minimum 2 witnesses. Registration is not compulsory for the will. So यहाँ पे B will produce that though my father consulted lawyers, and he will examine the lawyer's office. Did my father had come to you? Did you give advice to him? Did he make any will? Have you acted as a witness? Is anybody came to you acting as a witness? I mean, the father did try to make preparation, but he has not made the will. So the other son who said that my father died intestate, the property has to be divided pursuant to the Succession Act. Equally, the court may hold that. The other son is trying to usurp the entire property. The will was made entirely giving my property and only right to leave to my brother, other brother, younger brother, or my mother, right of maintenance and no other rights. So in such a scenario, what steps was taken by the deceased testator? You will be entitled to lead evidence in a suit under the Succession Act when you go for a probate. When a suit is filed for administration of the property of the deceased. Please note that under the Indian Succession Act, when the family dispute unfortunately erupts, you file two types of dispute. When there is a will, you file a probate. When there is no will, letters of administration can be filed. And when there are a lot of disputed fact, will and letters of administration, they don't give you title. Please note that. They only acknowledge the fact that you are the heir and legal representative, or that the will is genuine or bogus. That is it. But you will be required to file a suit for administration, for a declaration that the properties were of the late father, grandfather. He left behind several properties, and you are under the Hindu Succession Act, one of the heirs. Properties be administered and distributed according to law. That is called a suit for administration. तो उसके अंदर these types of evidence can be led by examining the advocate, by examining the secretary of the advocate, by examining the typist, by examining the attesting witnesses, if any. If there are no attesting witnesses, why can lead? Evidence can be led both the way. You can lead evidence to prove the fact under section 4. You can lead evidence to disprove the fact, or you can lead evidence in rebuttal to prove the fact that the evidence given by your adversary is wrong. Your brother's evidence is wrong. My father was suffering from dementia. My father was suffering from a serious mental disease. He could not have made the will. Then you have to follow the Indian Mental Health Act, formerly Lunacy Act. Such a thing was not happen. The medical doctor gave an opinion. In that matter, he would not be able to remember. ये सब चीजें you will be entitled to lead evidence. Huh? Please remember this. Civil cases के अंदर that will show the preparation, motive, and the subsequent and previous conduct of the various witnesses. That is how you lead evidence in the court of law. That is how the Evidence Act helps you in presuming it. Okay, next is E. A is accused of a crime. The fact that either before or at the time of or after the alleged crime, A provided evidence which would tend to go to the facts of the case, an appearance favorable to himself, or that he destroyed or concealed evidence, or prevented the presence or procured the absence of persons who might have been witnesses, suborn persons to give false evidence respecting his relevant. Very interesting illustration. I will explain to you each and every word of this. A is accused of the crime. So A is trying his best to dislodge the prosecution. Now what is this man is saying? He is trying to sabotage everything. Number one, either before or at the time of the alleged crime, A provided evidence which would tend to give to the facts of the case an appearance favorable to himself. Now here he will say that at the time of the commission of the offense, I was not in Bombay, I was in Calcutta. So that evidence is a favorable evidence to him. So he is dislodging it, that he is trying to show before the court of law when he was not in Bombay, he is taking the plea of alibi. So his intention was he has procured, the prosecution can dislodge it by saying that no, he has fabricated these tickets, plane tickets, on fictitious name. He has pre-planned it. His intention was to commit the murder from the very beginning. चीटिंग करने की क्या नाम तय पहले से किया था उन्होंने. Yet, he has pre-planned the entire conspiracy and made arrangement. He has made false entries in the company of Mr. X. He took book bogus tickets in his name, but he did not go. ये सब चीजें you can dislodge it. Accused will prove that no, I am innocent. I was not there. I take up the plea of alibi. So that is favorable to him. Okay. That evidence, if the court believes, the prosecution goes away. Number one. कहाँ पे? Which he would tend to give favorable. Number two, or that he destroyed or conceal evidence. So murder करने के बाद इन्हें क्या किया? डेड बॉडी को जला दिया. एविडेंस ना रहे बांस ना रहे बांसुरी. Isn't it? Enmity थी. Many cases you are reading in newspaper. In Sheena murder case, the Mukherjees, the mother and the stepfather, they burned the body in the jungle of pain. Body skeleton मिला आपको. Completely flesh जल चुका था. You cannot recognize it. Only the DNA test can give evidence. So यहाँ पे attempt was made to destroy evidence, conceal evidence, which is an offense under section 201 of the Indian Penal Code. All of you know that. So you can see that here, after committing the crime, he tried to wipe it out. There are locals who have seen him. He had gone there, and DNA test establishes the fact that it was the dead body of Mr. X. The last seen company was that of the accused person. He made preparation to destroy the evidence. In fact, succeeded. So you will be entitled to lead this evidence under Section 8 of the Evidence Act to prove that his intentions, his preparation, his motive in destroying the evidence. Okay. Conceal evidence. Next. Or prevented the presence or procured the absence of person. Prevented or procured. अभी तो देखते हैं आप. Lots of crimes you are witnessing in the election times in India. Influential people are giving threats to witnesses. If you go and report to the police, I will wipe out your family. मालूम है ना आपको? In UP के अंदर the girl was molested and raped and her dead body was consumed to fire. She was without even conducting examination. The parents were threatened, if you lodge a complaint, we will teach you a lesson. The matter under investigation. You will be permitted to lead evidence to show that here we were prevented from lodging complaints. We were prevented from informing the lawful authorities, and threats of dire consequences they were given. ये होता ही है. You are reading newspaper. If you follow it up, newspaper every day होता है. Election times are many election crimes are being committed. All political parties do this. Nobody is a paragon of virtue. Nobody can be given a clean sheet according to me. Every party, every individual, without exception, do it. No, it is only difficult to find out who is clean, who is not clean. Only the court will tell you. Only the trial, if the fair trial takes place. But these political parties and influential people not allowing a fair trial to take place. How evidence is procured, how evidence is destroyed. You will be entitled to prove this under Section 8 of the CAT. Procured that the absence of person who might have been witnesses, unsuborn, or to give false evidence respecting it are relevant. Witnesses were bribed. They were told to retract their statement. So you can lead evidence before the police at the time of investigation under Section 161, 162. This man accepted, gave evidence implicating the accused. Now in the court of law, he is retracting this statement. Why? Because he has been bribed. The witness, who was otherwise a very poor farmer, he had no money. Now overnight he got a tractor. कहाँ से मिला उसको? पूछेगी police prosecution. A good public prosecutor, a good lawyer will ask him, ये ट्रैक्टर आपको कहाँ से मिला, कभी लिए, कहाँ से लिए, दाम क्या थे, बैंक अकाउंट बताइए. Why? Because ever since his name was cited as a witness and his retraction took place, he was awarded with a lot of money. समझे ना? Bribe was given. You are impeaching his credibility by showing him that you have been bribed. That evidence you are permitted to lead under section 8, read with section 155, खोलिए 155, subclause 2, impeaching the credit of a witness by proof of the witness has been bribed or accepted offer of the bribe, received any other corrupt inducement to give evidence. So जो आदमी गरीब था, फकीर था, उसके पास कुछ नहीं, ओवरनाइट बैंक बैलेंस बढ़ गया उसका, घर आ गया उसको, 3 bedroom हॉल किचन, फार्म ले लिया, बैलगाड़ी की जगह ट्रैक्टर भी आ गए, सिनेमा हॉल भी खोल दिया, ये सब पैसे कहाँ से आए थे? That evidence can be led pursuant to section 8 of the act. Please note that. Okay. When you become a lawyer, you should do this. Remember this section very well. Because just don't read FIR, don't read everything. Remember this, and ये सब चीजें करना पड़ेगा आपको. Yes, relevant. So these are all relevant evidence. You cannot be told, shut by the court or others. You must tell the court, I am entitled to lead this evidence under section 8. Next, लीजिए. E हो गया. F. The question is whether A rob B. ये robbery का केस है. The fact that after B was robbed, C said in his presence, the police are coming to look out for a man who robbed B. That time, immediately afterwards, he ran away are relevant. So here the conduct of the A shows that he was scared of the police coming. An announcement was made by C. Though he may not himself be a robber, but the conduct shows he made preparation to run away. Why? Because a guilty conscience pricks the mind. He wanted to skip the police. He wanted to bypass the police. So evidence can be allowed to be showed that here, one of the circumstantial evidence, this is a circumstantial evidence. At the scene of offense and nearby, the neighbor made an announcement. Police is coming. Police, I lodge a police complaint. They are coming in 10 minutes to catch the culprit who committed the crime. So one by one, 2-3 लोग वहां से फरार हो जाते हैं. That फरारी का evidence you can leave that. That is a good evidence to show the conduct. Okay, that itself may not be that the accused person has a right to rebuttal. He may say that I ran away from there not because I am thief. I had to attend an important call. मुझे फोन आया कि there was a death in the family. I had an examination to attend to. I had to go to the railway platform. Railway, whatever reason, give a plausible evidence. As a young lawyer, you must think properly and give proper evidence to put your client out of the clutches. Plausible and acceptable evidence should be led. Of course, in the process, there will be a lot of omissions and omissions. So how you defend your client is a matter of is a tactics to be adopted by each defense lawyer. Sometimes you cannot tell the court the entire gospel truth. Pakda jayenge aap. Some evidence you have to lead. Even you cannot fabricate evidence, court mein pakda jayenge. It must be believable evidence. It must be believable to the eyes of the court. So यहाँ पे the gentleman ran away the moment he heard that police is coming. ये illustration आपको section 114 में भी मिला था, isn't it? Police is coming to look out for a man Who stole it? 114B. Huh? I read out to you someplace. Yes. Yeah. Next illustration देख लीजिए. G. The question is whether A owes rupees or A owes B rupees 10,000. अब ये criminal केस के बाद एक civil केस है. The question is whether A owes B 10,000. The fact that A asked C to lend him money and D said in E's presence and hearing, I advise you not to trust A, for he owes B 10,000, and that A went away without making any answer or relevant fact. तो यहाँ पे D tells him, C को, don't trust this man. He is not reliable. So having lent the money, money was not returned. You can examine D to prove what he said. So because he will show the acquiescence, the conduct, he did not rebut his conduct. Okay, when D said to A is unreliable, वो चुपचाप चले गया. Normally he will resist. ना? Why you want to defame me? इसका मतलब पैसा लेके हजम करके उसने पैसा नहीं दिया है. He believes in deceiving people. Take the loan and not return it. So it doesn't have defense. So his conduct is not free from blame. Okay, that evidence can be led in civil proceeding to show that such a loan was taken, loan was not written, and in fact, he had suggested to me not to give him, and he ran away without saying anything. There was an acquiescence on this part and amount. Okay, next लिख लीजिए आप. G, H. The question is whether A committed a crime. Again, criminal case. देखो एग्जाम में सब आएंगे, आपको ध्यान रखना. The question is A committed a crime. The fact that after the commission of the alleged crime, he absconded or was in possession of the property or proceeds of the property acquired in the crime, or attempted to conceal things which were or might have been used in committing are relevant. Your neighbor stole your diamond ring, gold coins. You may be a rich man, a jeweler in the locality, and he knows in and out. He may be your employee or agent. डाका डाल के निकल गया. He ran away to his native place. He was in the employment drawing a salary of just 3,000 from you. So he ran away to his native place. You lodge a complaint कि मेरा 1 crore rupee has been stolen, and the prime accused is my own employee. वो deny करेगा. So the police investigation will start from the provisions of section 157 onwards. Under 165 CRPC, the police will conduct raids. Overnight raids going to his native place. Makes inquiries. मालूम हुआ कि the servant who was otherwise living in a small slum or chart, he has acquired a decent flat for himself and decent bank balance and got a nice tempo doing a business. All these facts are relevant. To prove that he became rich on account of the booty, the amount he has committed, crime, collection money. So you can examine the tempo owner, ये tempo कहाँ से लिया, कितने में लिए. You can examine the builder locality, ये पैसा कितने दिया आपको, कैसे दिया. You can examine the bankers, कहाँ से आया पैसा इसको, कितने दिया. So these are all circumstantial evidence you are connecting. You are permitted to lead this evidence to show the conduct of the accused person, the previous preparation he has made it, subsequent conduct, previous conduct. पहले उसकी क्या हालत थी, and now he has become prosperous. How he became, that evidence you can lead before the court. Okay. Now, H है ना भी. The question is whether a committed crime. ये हो गया क्या? Abscond, yes, हो गया. H. Yes. जी H हो गया. I में आ जाइए आप. 3 more illustration will stop it. The question is whether A was ravish. Ravish means a rape का case है. The fact that shortly after the alleged rape, she made a complaint relating to the crime, the circumstances under which the terms in which the complaint was made are relevant. A young schoolgirl was ravished by a school peon or maybe a teacher. Having regard to her tender age, she was afraid to lodge a complaint. She did not report to police, she doesn't know. She was afraid that even if I tell my mother will scold me. And after picking up courage, she tells to one of her elder sisters after 6-7 days. Normally, FIR should be lodged immediately. But in a crime of ravishment, rape cases, having regard to the tender age of a girl, social condition, stigma, the court like to see that here delay itself is not fatal. So evidence will be collected by the police. What prevented the girl from lodging FIR immediately? Circumstances, school she went, the tuition she goes, the company of the friends, all will be examined. All their statements are relevant in this matter to prove whether the girl was, how she was ravished, whether she was alone at that time. The peon under the garb of taking her to teacher took her in a bathroom and locked her and did the act. And he gauged her so that she did not shout and listens, tying a towel or sari to her mouth and made her unconscious. A medical report coming, the girl was unconscious. She did not know the nature of the act. So these are all factors are important in such matters, the various circumstantial evidences. The medical report, the statement of the girl under section 164. She makes a statement. Now videography is compulsory. The witnesses who have been examined under, some of the witnesses under 161, 162. The girl's statement recorded under 164. The medical evidence, medical officers examine. The DNA report. The peon, the teachers, her classmates. Unke all statements are relevant to prove this fact. Okay. That is, the fact that without making a complaint, she said she had been ravished is not relevant. The fact that without making a complaint, she said that she has been ravished is not relevant. as conduct under section, though it may be relevant as a dying declaration under 32(1). I'll explain to you this. If she wants to take the benefit of section 8, she must lodge a complaint, written or oral complaint. Pursuant, the police examines. But she did not lodge a complaint. At the time of the offense or immediately subsequent thereafter. But in a feeble condition, she was taken to hospital. She was repeatedly raped and she was getting fever, which is not coming down, maybe 10 days, 15 days. Then she tells the nurse what happened. She tells the doctor that I was ravished, so-and-so boy was responsible for committing the crime. Because she had not gone to the police station. Here the statements made to the nurse and made to the surgeon relating to the circumstances of a death are relevant under section 32 clause 1. Just open 32 clause 1. Section 32, these are all hearsay evidence. When they become relevant, 32 1 check kar lijiye. It's called dying declaration. Cases in which statement of relevant fact by person dead or cannot be found are relevant. Statement written or verbal of relevant fact made by a person who is dead, cannot be found, who has been incapable of giving evidence or whose attendance cannot be found without the amount of delay, expenses under the circumstances, quote, unreasonable, or relevant in following cases. Number 1, 32A mein aayega ladki ka. Number 1, when the statement is made by a person, here the girl, as to the cause of her death or as to any of the circumstances of the transaction which resulted in the death, in a case which the cause of death person becomes a question. Such statements are relevant whether the person who made them was or was not at the time when they were made under the expectation of death, whether by the nature proceeding in which the cause of death comes into play. So the girl did not know that she was repeatedly ravished. She subsequently became ill and high fever, and unfortunately she succumbed to it without lodging a complaint. So the statement made to the nurse or to the surgeon, doctor in the hospital, or to the next neighbor in the hospital, or if she has not gone to the hospital or told to a friend or to a mother, they become admissible under 32(1) because she had not lodged a complaint. Had she lodged a complaint, those statements would have become admissible under section 8 for motive, preparation, conduct against the accused person to implicate him. Now, when a complaint is not lodged, when she makes a statement under 32, when she dies relating to circumstances, they become admissible upon her death. Please note that. 32, number 2, or as corroborative evidence under 157. Corroborative evidence means somebody is stating on her behalf. The nurse is produced before the court. Section 157 khol lijiye aap. 157 says question tending to corroborate evidence of relevant fact. When a witness who is intending to corroborate gives evidence of any fact, he may be questioned as to any other circumstances which he observed at or near the time, place at which such relevant fact occurred. If the court of the opinion that such circumstances, if proved, would corroborate the testimony of the witness as to the relevant fact testifies it. Yahan pe the nurse will give evidence. Yes, this girl was brought to the hospital. Yesterday, she was in high fever. I asked her what happened. She narrated to me the incident that she was raped by certain people, A, B, C, D. I reported the matter to the surgeon. Surgeon also gave a call to the police to recommend. By the time the police came, she died. So here she made a statement to the nurse is relevant under 32. And the nurse coming and stating her state of health and her story becomes admissible under 157. Please note that admissible both under 32. 32 ke liye somebody else, A dies and goes. Dying person cannot come to the court. Somebody who heard it, story, uski kahani, that person, the nurse here, she can come as a good witness. Her statement, she is deposing with regard to the dying declaration, circumstances leading to her death, number one. And under 157, she is corroborating. Yes, she made this statement in my presence. I heard it. I reported to my senior doctor. Further corroboration means immediately medical examination was done. The doctors had done a DNA test, her vagina test, her seminal test. These are all revealed that she was ravish. Her vagina was ruptured. Huh? She's a girl of tender age, 13, 14 years old. But there were marks of injuries found. These are all corroborative evidence. Please note that corroborative evidence under 157. It will be a good evidence for convicting a man. Number 3, last dekh lijiye, illustration. That the question is whether A was robbed. Robbery ka case hai ye. The fact that soon after the alleged robbery, he made a complaint relating to offense. Circumstances under which the terms in which complaint was made are relevant. So illustration 6 में पढ़े आपने. Gentleman goes to fair Kumbh Mela with notes and displaying it to everybody. और चोरी हो गया. Isn't it? He goes to the police and makes a statement. मैं कुंभ मेले में गया था. My fault was that शॉपकीपर को मैंने सामान लेने से मुकरा गया. शॉपकीपर told me, provoke me, तुम कड़का आदमी है, तेरे पास कुछ भी पैसा नहीं है. तो मैंने जोश में आके जेब से निकाला 1 लाख रुपए दिखाया और 3-4 लोग आके लेके अटैक करके ले चले गए. So complaint was lodged. So the conduct of the complainant is relevant. That in excitement he took out from the pocket money to show to the shopkeeper, don't call me Kadka. And as a result, the bystanders who was listening, they came and robbed and went in. So that will show the conduct of this man, the preparation they made, and their own, the robbers, how they flee. Then the fact that they said rob man without making any complaint. अगर वो complaint नहीं करेगा, earlier case, complaint is not relevant. Section 8 के अंदर नहीं आएगा. The conduct and section, though it may be relevant under 32 and 1. अगर वो मर जाएगा तो whatever he said to the shopkeeper can go and depose. ये young man आया था खरीदने के लिए. When I told him it will cost you 55,000, he just kept out. And I told him, when you have no money, why you want to do come shopping? Then he took out from his pocket 1 lakh and displayed. And though no sooner he removed the money, 4 or 5 people who were standing, they robbed the money and went away. और he began chasing them. उनको पकड़ने गया और वो chasing में उसको मार दिया उन्होंने. वो मर गया. So that statement becomes admissible under section 32 of the shopkeeper and the people in the Kumbh Mela. Okay, the gentleman who took out the money, the victim ran after the robbers to attack them. He took his revolver, maybe, like they were so powerful, they overpowered him, they killed him. So that statements of the shopkeeper and the people who are collected bystanders become admissible as dying declaration, because उसने बोलेगा मार दिया मेरे को, मेरा पैसा लेके भागा उसने 1 लाख रुपया, मारा उसने मेरे को, मारा the gentleman. So those statements are admissible not only under section 52, 57 and also under section 6 as res geste statement. Okay, आज का टॉपिक बंद. Anybody has any question? पूछ लीजिए. Anybody has any question? समझ में आया?
Good evening, sir. Sir, good evening.
Good evening.
Sir, my question is that where the girl who was ravished or the person who was robbed gets robbed and does not die, but does not lodge a complaint also. But in the case of this ravishment, if the nurse makes a complaint, would that be relevant of the ravishment of the girl?
When the girl doesn't die.
Girl doesn't die, girl doesn't make a complaint, but she has confided into the nurse while she's undergoing treatment, and the nurse makes a complaint to the police that the girl has been ravished.
When the girl itself has not made a complaint, under section 8, they are not relevant. See, the girl complainant itself has not lodged a complaint. Then why the nurse is going and lodging a complaint? At whose behalf? Matter police के पास गया ही नहीं है.
Okay,
and the girl is alive. Prosecution start ही नहीं हुआ है.
Say girl's fears for her life and somebody will kill her and she doesn't lodge a complaint, but
Yes.
if nurse is now aware of a commission of a crime.
Nurse can go and lodge FIR. There is no bar. Police will investigate.
Okay.
Police will investigate. Then the girl will also necessarily has to corroborate the nurse. Then only it will become FIR. Then statement will come under 8 because it will be regarded as a complaint case.
Understood. Thank
if
you,
no complaint is lodged, then section 8 cannot be invoked. But in case she dies, 32 and 157 can be invoked. और कुछ पूछना है पूछ लीजिए.
So just a quick question.
Yes.
So sometimes we say that in offenses like rape and sexual harassment cases, girl tells something to someone and they tell them to, before lodging a FIR, 3 to 4 persons are also involved. So what is the evidentiary value of such a statement if defense takes a claim that it is a concocted statement and it eventually will harm the evidentiary value of the witnesses and the FIR as well?
It is subject to investigation and subject to cross-examination. समझे ना? How the police officer investigate the matter to find out whether the, of course, medical evidence भी आएगा उसके अंदर, testing करेंगे, statement of the girl under 164 जाएगा उसके अंदर, medical evidence आएगा, DNA examination होएगा, vagina examination होएगा, then the witnesses who have seen, the direct witnesses, the scene of the offense, collection of the semen, the clothes of the accused and the girl, they all will be seen. It is a cumulative effect of the investigation and a cross-examination, searching cross-examination if you want to dislodge, okay, this is a concocted story. You can take up the plea, I was not there. Section 11, alibi. You can take up the plea that your witnesses are planted. You can take up the plea that medical evidence is not matching. These are many things for defense. There are many things for a different. Section 145 may corroboration, contradiction, impeachment under 153. So it's not that the accused doesn't have legal right, too many. But if a clinching medical evidence is given and supported by the evidence of direct witnesses who have seen, prosecution can make out a good case.
Yes, sir, got it. So also, sir, one more thing, delay in lodging FIR and recording the statement of witnesses is also one factor that we came
Yes.
across in during the trial.
Delay itself is not, especially in rape cases, the courts are very lenient. Having regard to the social conditions in India, the women are scared to go to the police. They feel shy to report to anybody. Their chastity questions are involved. They do not want to disclose it. So the courts normally take a very lenient view, and delay is condoned normally. But delay aspect is good only for consideration of a prayer for a bail. If immediately FIR is not lodged within 20 minutes, half an hour, depending upon what the distance is from the police station, or half a kilometer, it should have been lodged immediately if report was given. If delayed हो गया दो दिन 3 दिन 4 दिन 6 दिन हो गया, then the court will say that it's a good case for bail, but not a good case for a trial. Trial will go on. Trial cannot be quashed on the ground that there is a delay in filing FIR, because the police also has a right to file charge sheet anytime, even after 90 days, 300 days, 1 year, 2 years. CRPC doesn't prescribe a time limit for filing a charge sheet. You know that now. Only for the purpose of getting statutory bail, you have to file it in 90 days. If you don't file it, what? You can file any time. बोलेंगे बहुत लंबा मैटर है, 10 witnesses हैं, 5-6 अमेरिका लंदन में. We need Interpol's report. We need a FBI's report. So the police can always delay it. 173 subclause 8 के अंदर always can be delayed. So it is not very fatal for prosecution of a matter trial के लिए. It is definitely fatal for consideration of a prayer for bail. Accused will be let off on bail.
Okay, sir.
Or anybody has any more queries? Acha, Kumar, I will not be available on Wednesday. We can keep our lecture on Wednesday. I will directly take you on Friday. Even I can take it on Saturday if I'm available. So Wednesday, please skip it. I have a very big arbitration. I will be busy whole day and evening. I will not be available.
Okay, sir.
Please note that. Wednesday I will not be available. We'll take it on Friday. Okay?
Sure, sir. Sure, sir.
Yeah. बोल दीजिए because बगाएंगे. और सर जब जजमेंट लेंगे नेक्स्ट सेक्शन 9, 10, 11 ले लेता हूँ अभी. Slowly, of course, connecting with the other section. Hopefully,
Yes.
for today's purpose, all of you understood section 7 and 8. And now read the judgment of R.M. Mulkani, Yusuf Ali Nagari's case. That will connect directly to section 7 and 8. दोनों जजमेंट आपको मैं फॉरवर्ड किया हूँ, चेक कर लीजिए आप. यूसुफ अली नागरी, R.M. Mulkani, as well as R versus Maqsood Ali's case. वो देख लीजिए आप. Those of you want it. Even if you read R.M. Mulkani is very clear. Then I will read and discuss with you what is the effect of even the judgment of the Constitution bench in Baldev Singh's NDPS के matter में. वो भी forward किया मैं. When if an investigation is conducted in breach of section 50, no conviction. Evidence led is zero value. वो जरा check कर लीजिए आप. Those of you want to ask me questions, I am prepared to deal with it. Okay, then all of you, good night.
So, so just a request.
Yes.
So just a request. So if you could forward two cases. So one, when you say that CPC and